So am I free to go? So why am I not free to go? If she just said she got a bond.
Pardon?
Why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So when I was arrested, I wasn't actually told my rights. So ain't that against the law?
I cannot.
You can't do nothing about it right now?
All
right, I just want to state that. I just want to state it. Okay.
Stated.
It's on record, right? Okay.
Do you want a jury trial or not?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury. Fine. That's fine with me.
She walked into that courtroom carrying an attitude so loud it filled the room before she even spoke. From the moment proceedings began, her behavior crossed a serious line, including openly raising her voice at Judge Simpson and demanding to know why she wasn't being released, despite being in custody on an assault charge. It was a stunning display of entitlement, as if the basic rules of the legal system simply didn't apply to her situation. What stood out even more was a contrast between her conduct and the judge's response. Judge Simpson remained composed, deliberate, and professional throughout the exchange, showing a level of restraint that many would struggle to maintain. Where others might have reacted sharply, he chose calm authority instead. The tension in the room made one thing clear. This hearing wasn't just about a charge. It was about accountability. And the real question becomes whether someone who approaches the court this way has earned leniency or whether consequences are exactly what's required. Let's take a closer look at how this unfolded.
Good morning, Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So, in this matter, Ms. Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and/or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation, in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time
I served 30 days already.
and if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim's loan.
And the monetary amount?
5,000,
10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
All
right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
So
Okay.
what do we do?
Situations like this are always difficult to watch because they reveal a fundamental misunderstanding of how the justice system works. When someone is facing a serious allegation like assault, the logical step is to seek legal counsel and approach the court with respect, not confrontation. Raising your voice at a judge isn't a strategy. It's a fast track to making things worse. What we saw here wasn't confidence. It was immaturity masquerading as defiance. That kind of behavior doesn't just undermine your own case. It highlights a deeper issue. Entitlement at this level isn't merely irritating. It becomes a public safety concern when it's paired with violent charges. While she remains in custody for now and may be eligible for bond, her courtroom demeanor raises serious questions about judgment and responsibility. That's unsettling because this mindset isn't rare. People who believe rules can be negotiated through aggression don't disappear after a hearing. They're part of everyday society. Courts exist to impose structure and fairness, but individuals like this attempt to turn them into stages for personal outrage. Against all of that chaos, Judge Simpson's steady approach deserves recognition. His consistency, experience, and patience place him among the most disciplined judges currently on the bench. He's firm when necessary, restrained when appropriate, and unshaken by theatrics. Encounters like this explain why that balance matters now more than ever.
What do you want this set for, ma'am?
I mean, Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. If I guess
You want a jury trial or a non-jury trial?
it doesn't really matter.
Well, you've got to make a decision, ma'am.
If it gotta go to trial, then it gotta go to trial.
Okay. Do you want a jury trial or not?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury. Fine, that's fine with me.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person.
So am I free to go? So why am I not free to go? If she just said she got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out.
If you
But she just said it was no bond.
post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by Kearney. The whole
That's-
McDonald's thing and then this. And
This-
If this initial hearing is any indication, the upcoming trial is likely to be intense. The tone she set here suggests that accountability will be difficult for her to accept, and jurors tend to notice that. Based on the circumstances, a full sentence is absolutely within reach, especially if the evidence supports a charge. Whether it's weeks or months behind bars, every decision from this point forward carries real consequences. Even setting sentencing aside, her attitude alone made this proceeding exhausting to observe. It placed unnecessary strain on a process designed to be orderly and fair. One moment that stood out was her reaction as she exited the courtroom, directing visible frustration toward her former attorney, an attempt to shift blame rather than take responsibility. But the reality is simple. Legal counsel doesn't create charges. Actions do. Cases like this reinforce why the justice system cannot bend under pressure or volume. If consequences disappeared the moment someone became loud enough, courts would lose their purpose entirely. So the question remains, should the sentence stand as a lesson in accountability, or should the court offer another chance at freedom? Share your thoughts below. As always, thank you for watching, and we'll see you next time.